When a party materially breaches a contract, the injured party may generally elect to either continue or cease performance. But what if a party continues performance and fails to provide the other party with timely notice of the breach? Does this failure constitute a waiver of the right to sue for the breach? The Alaska Supreme Court considered this question in Carr Gottstein Foods Company versus Wasilla LLC. Larry Carr owned Carr's grocery store and Oaken Keg liquor store. In the 1970s, Carr merged his companies with another company owned by Barney Gottstein. The merger created the Carr Gottstein Companies, including Carr Gottstein Properties, which we'll call CG Properties, and LABAR Company, a partnership. LABAR owned the Wasilla Shopping Center in Wasilla, Alaska, and CG Properties managed the center. Two of the center's tenants were a Carr's grocery store and an Oaken Keg liquor store. Under the grocery store lease was a use clause that stated that the tenant would use the premises as a food supermarket. In 1990, an investment group purchased the stores but didn't buy the shopping center. Further, the group owned the stores through a corporation named Carr Gottstein Foods Company, which we'll call CG Foods. In 1996, the liquor store moved into the grocery store. CG Properties knew of the relocation and didn't object or claim the relocation violated the grocery store lease. In 1998, LABAR transferred ownership of the shopping center to another Carr Gottstein entity, Wasilla LLC. That year, Wasilla borrowed money from a third party, and its general manager signed a sworn statement that the leases in the shopping center weren't in default. In 1999, the group sold CG Foods to Safeway. Safeway asked CG Properties to declare that there were no defaults under CG Foods leases, but CG Properties didn't respond in a timely manner. 3 years later, CG Properties wrote to Safeway to state that it considered the liquor store's move into the grocery store a breach of the grocery store's lease. Subsequently, CG Properties, acting through Wasilla, sued Safeway, CG Foods, and Oaken Keg in state superior court, seeking a declaratory judgment and permanent injunction. In response, Safeway answered and pled affirmative defenses, including waiver. Following trial, a jury found that CG Properties was estopped from enforcing the use clause in the grocery store lease. The court rejected the jury's finding regarding estoppel and entered judgment for CG Properties. Safeway, CG Foods, and Oaken Keg appealed to the Alaska Supreme Court.